Hi, it's Guy DiMartino with my 1-minute Indiana estate planning tip. I can tell you that this week I received 5 phone calls with folks, and this is how the phone call went. I would like to get a power of attorney for my mom, dad, friend, sister, cousin, whoever. My response to them is the person competent? Answer, after a moment of silence, no. That's why we need a power of attorney. I said, so sorry, I cannot help you. Why? Because a power of attorney is a contract. A power of attorney is a document where I say that I am appointing you to be my attorney in fact to go ahead and take care of my financial business, sell a piece of real estate, or I can give you all the powers to take care of me personally, my estate, and my finances. So, in order to have a valid contract, you have to be competent to enter the contract. So if you are incompetent, if you're unable to understand what is being written and assent to that, you do not have a valid contract. No valid contract, no valid power of attorney. The only option that you have at that time, filing for a guardianship. What does that require? That requires opening a case in court, filing a petition, medical testimony, giving notice to any potential party of the guardianship, going to court, having to bring the medical testimony into court, having a judge make a final determination that your loved one or your friend or the person that you care about, your neighbor, whoever it might be, is not competent, appointing a guardianship, having the court standing over the guardian, making sure that they give proper accountings and handle the person and the estate properly, and it equals a ton of money. Somebody is going to have to pay for the lawyer's time, the doctor's time, the court's time, all that stuff. And all this could have been taken care of much earlier when your friend, your family, your neighbor, your loved one, whoever it is, signed a power of attorney when they were competent. They could have made the power of attorney what we call spring forward and only come into effect when they became incompetent. So at that point in time, all you would need is a letter from a doctor saying the person doesn't have the necessary mental capabilities or physical capabilities at this point in time to handle their own affairs, and then you would be able to use the power of attorney, and you wouldn't have to go to court unless you have a problem from a bank or some organization, and then you finally need to bring them into court to get the situation handled. So there you go. If you want a power of attorney, the person who is going to execute the power of attorney needs to be competent. They can't be senile, they can't be demented, they can't have Alzheimer's disease, they can't be in a coma. They have to be competent. If you have any questions about an Indiana estate matter, you can always give me a call. I am Guy DiMartino. Have yourself a great day.